Before the rise of the Senate, at 1:15 p.m., the Senate had concluded the hearing of the case of the National Assembly. This included the evidence laid by the National Assembly, including the calling of its witnesses who were examined, cross-examined by counsel for the Deputy President, and re-examined. As the House adjourned, I directed that, as contained in the hearing program in this matter, of the determination of the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. On resumption at 2:30 p.m., the Senate will hear the case of the Deputy President for 2 hours, comprising examination in chief and re-examination, while the National Assembly will have a period of 1 hour and 55 minutes for cross-examination. When the Senate resumed at 2:30 p.m., when the opportunity came for the Deputy President's side to commence its case, Senior Counsel Paul Mwite, counsel for the Deputy President, informed the Senate that he did not know the whereabouts of his client and sought to be allowed a little time to establish where he was. Thereafter, he informed the Senate that he had learned that his client had been taken ill. Asked how he proposed that the Senate proceeds, counsel for the Deputy President requested for time, possibly up to 5 p.m., to try to meet his client before advising on the way forward. Counsel for the National Assembly, when asked to comment on the circumstances, argued that, unfortunate as the situation was, this being a constitutionally time-bound process, it was imperative that, pursuant to Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, the proceedings proceed. Now, I'll read Rule 11. It provides thus: where the National Assembly or the Deputy President chooses not to appear before the Senate, that fact shall be put on record, and the Senate shall proceed with its investigations without further reference to the National Assembly or the Deputy President. But the Senate may, for exceptional reasons to be recorded, permit a later appearance before the Senate by the National Assembly or the Deputy President. Now, honorable senators, it is also noteworthy that Rule 12 provides as follows: subject to these rules, the hearing of the evidence, once it commences, shall proceed and continue until the Senate conclude the hearing of the matter. Following the representation made by counsel for the parties, I suspended the proceedings of the Senate up to 5 p.m. to allow counsel for the Deputy President to report the status of his client. When the sitting of the Senate resumed at 5 p.m., Senior Counsel Paul Mwite informed the Senate that indeed he had contacted doctors at Karen Hospital who were attending to the Deputy President. He further stated that, owing to the condition of the Deputy President, he had not been able to access the Deputy President or talk to him. Senior Counsel then proceeded to cite Article 145(6), observing that although the Senate had opted to proceed by way of hearing the matter in plenary, and while Article 145(6) provides for the hearing of the matter by way of special committee, the provision obligates the Senate to accord the Deputy President an opportunity to be heard before a vote is taken on the impeachment charges. He further cited Rule 11 of Part 1 of the second schedule to the Senate Standing Orders, stating that in accordance with the provisions, the Deputy President had chosen to appear and be presented in these proceedings. Counsel for the Deputy President further submitted that the right of the Deputy President to be given an opportunity to be heard under Article 145(6)(b) of the Constitution is not limited by the 10-day timeline otherwise provided for in this matter. In the end, relying on these provisions, counsel for the Deputy President requested that the Senate adjourns the matter to Tuesday, the 22nd of October 2024, to enable his client time to be attended to by his doctors. In response, counsel for the National Assembly, Mr. Gumbo, registered his sympathies to the Deputy President. On the other hand, he noted that the health matters are matters that are beyond human control. However, he noted that the matter at hand was one that was governed by constitutional timelines. Counsel further indicated that Article 145(6) of the Constitution applied to impeachment proceedings in committee and was not therefore relevant to the present proceedings, which had been convened by dint of Article 145(3) of the Constitution. Council observed that the dates for the hearing had, by Gazette notice, been set at 16th and 17th of October 2024. Council therefore went ahead to observe that His Excellency the Deputy President had robustly participated in the proceedings by filing detailed responses to the allegations as set out by the National Assembly and through various submissions made in the course of the hearing, including cross-examination of witnesses. Council then indicated that if any prejudice was to be suffered by the failure of the Deputy President to testify and be cross-examined, this will be on the part of the National Assembly, which had the legitimate expectation of testing the evidence of the Deputy President through cross-examination. Council then referred to the practice in the courts, including the Supreme Court, where parties are allowed to file respective submissions, and the advocates are then allowed to appear and highlight their submissions. Council argued that noting the Deputy President had filed detailed responses and had the opportunity to cross-examine the witnesses of the National Assembly, the health status of the Deputy President, and the constitutional timelines, and borrowing the practices of the courts, the National Assembly was willing to forego the cross-examination of the Deputy President and requested that both parties be allowed to highlight their submissions during their closing statements. Senior Counsel James Orengo had similar sentiments and cited Article 145(5) of the Constitution, arguing that the right to appear and be represented include the right to be represented by counsel. He argued that the Senate that the greater duty was to comply with the Constitution, and that the Senate could not accordingly go outside the timelines as set out in the Constitution. It is noted that the present hearing was convened via Gazette Notice 163, Volume CXXV1, dated the 9th of October 2024. Via that Gazette Notice, I appointed Wednesday, 16th October 2024 as the date for the commencement of the hearing, and further that the hearing will run up to the conclusion of the hearing on Thursday, the 17th of October 2024. As presently convened, therefore, today at midnight, unless midnight finds the Senate in the course of division, marks the end of the period for the hearing of the present impeachment matter. As this process is time-bound by the Constitution to be concluded in not more than 10 days, pursuant to Article 145 as read together with Article 150 of the Constitution, and noting that the period provided for ends on Saturday, the 19th of October 2024, the only window open to the Senate, if it so oblige the request for adjournment sought by counsel for the Deputy President, will be to gazette Saturday, the 19th of October 2024 as a further and final day for hearing of this matter. Now, honorable senators, ladies and gentlemen, such a request is not made to the Speaker, but to the Senate, and is accordingly a matter for the Senate to determine. To facilitate this decision, I direct the Clerk of the Senate to circulate a supplementary order paper incorporating a notice of motion and a motion for adjournment sought. This being a procedural matter, the motion, if carried, will result in the Speaker gazetting Saturday, the 19th of October 2024 as a sitting day to conclude the hearing and determination of this matter, this being the last day allowed by the Constitution of Kenya for these proceedings to conclude. Needless to say, if the motion is not carried, the decision of the Senate will be that this hearing continues to conclusion in the manner provided for under Rule 12. In such event, the hearing will continue as set out in the program, with the parties moving to make their closing statements. Now, honorable senators, ladies and gentlemen, in conclusion, let me take this opportunity on my own behalf and on behalf of the Senate to convey our sincere sympathies and best wishes for a quick recovery to His Excellency Rigathi Gachagua, AGH, the Deputy President of the Republic of Kenya. Next to the clerk. Now, honorable senators, you have been circulated with the supplementary order paper. That is the order paper that we are going to use from now going forward. Clerk. Now, honorable senators, this being a procedural motion, you don't need to give notice. So when the order is read out, the majority leader will be called upon to move. Clerk, call the order, please. Honorable senators, please let us be seated.
Order number 2, procedural motion to hold sittings on Saturday, 19th October 2024.
The Senate Majority Leader.
Mr. Speaker, sir, I rise to move this procedural motion, which is for the Senate to hold sittings on Saturday, the 19th of October 2024. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least two-thirds of all the members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution and the Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the ground specified in the motion. Whereas by letter reference NA/DLP/TBO/MTS/2024 025, dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, and on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas vide Kenya Gazette number 137/18, volume CXX V1 number 163, dated 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday the 16th of October 2024 and Thursday the 17th of October 2024 as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, by plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by way of impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders number 178, Standing Order number 78 and 79 of the Senate Standing Orders, the Senate also had the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, 17th October 2024, further noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, the Deputy President of the Republic of Kenya, to appear and give evidence, if any, on grounds for his proposed removal from office by impeachment. Further noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves as follows. 1. To adjourn today's afternoon sitting on Thursday, the 17th of October 2024, and pursuant to Standing Order number 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 until the conclusion of business in the order paper on that day. In order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Mr. Speaker, this is a self-explanatory procedural motion that, in light of the request of counsel for the Deputy President, this House adjourns until the closest time possible without violation of the Constitution within which we can sit and conclude on this matter. As I move this motion, though, Mr. Speaker, I must note that the request that came from counsel for the Deputy President, Senior Counsel Paul Mwite, is that we actually sit on Tuesday. I am sure he knows very well the 10-day provision, but I don't know why he wants this House to violate the Constitution, Mr. Speaker, or at least send us into a constitutional crisis. Be that as it may, Mr. Speaker, I want to urge my colleagues that let us sit on that Saturday, despite the fact that I know there are quite a number of Adventists, but duty calls, Mr. Speaker. And this is an important exercise that has the breadth of the country holding still while watching what is happening in the Senate of the Republic of Kenya. Therefore, Mr. Speaker, with those very many remarks, I want to request the minority leader, Senator Justice Stewart Madzayo, to second this motion. I thank you. Justice retired Stewart Madzayo. Sorry, my apologies.
Order, honorable senators. You know, it pays to be attentive. I've just said this is a procedural motion. It does not require notice. Senator Karungo.
Asante Mheshimiwa Spika. Kwanza nataka kuunga mkono hoja hii ya kwamba tuweze pia kupata nafasi ya kuweza kuketi ama kusikiza maoni haya siku ya Jumamosi, kuanzia leo mpaka Jumamosi, kupewa nafasi hiyo. Bwana Spika, tunaelewa ya kwamba hii ni kesi muhimu sana na macho yote katika nchi hivi sasa yanaegezwa katika bunge la Senate. Nataka kumpatia pole sana kupitia kwa wakili ambaye ni senior counsel wetu na ni wakili mkubwa katika Kenya, ndugu yangu Paul Mwite, kwamba yule client wako amekuwa mgonjwa wakati huu. Najua ni ugonjwa ni kitu cha Mwenyezi Mungu. hatuwezi sisi tukasema ya kwamba mtu hawezi kuwa mgonjwa. Mtu yote anaweza kuwa mgonjwa. Kwa hiyo nataka umpatie pole, Senate imempatia pole, na kwamba tunamtakia kila laheri aweze Mwenyezi Mungu kumpatia nafuu, alafu tuweze kumpata hapa. Bwana Spika, tuko katika panda mbili hivi sasa. Ni mgonjwa na tuendelee, ama ni mgonjwa na tusiendelee. Tumpatie nafasi. Kama binadamu naweza kusema kwamba ni nafasi nzuri tuonyeshe binadamu kama maseneta ama nyumba ya Senate kwamba tumpatie nafasi ya yeye akiwa yuko hospitali aweze kuweza kupata nafuu katika matibabu yake. Bwana Spika, mswada huu umekuja wakati mzuri na kwamba tunaweza kumpatia hiyo nafasi. Naunga mkono hoja hii. Asante sana Bwana Spika.
Which is that aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2) as read with Article 151(b) and 2 of the Constitution and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025 dated the 8th of October 2024 and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas Vide Kenya Gazette number 13178, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate heard the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses for the National Assembly on the grounds for the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024. Further, noting that counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of a Deputy President must be concluded within 10 days from the date of the reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves the following: to adjourn the afternoon sitting of Thursday, 17th October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Now, honorable senators, we have been here before. This is a procedural motion. We rarely debate procedural motions. It's either we agree with it or we don't agree with it. And therefore, with your consensus, I may move to put the question. Very well. I will now proceed to put the question. That aware that the National Assembly on the 8th of October 2024 resolved with the support of 282 members, being at least 2/3 of all members of the National Assembly, that pursuant to the provisions of Article 145(2), as read with Article 151(b) and 2 of the Constitution, and Standing Order 65(2) of the National Assembly Standing Orders, His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, be removed from office by impeachment on the grounds specified in the special motion. Whereas by a letter reference NA/DLP/TBO/MTS/2024 into brackets 025, dated the 8th of October 2024, and received in the office of the Speaker of the Senate on the 9th of October 2024, the Speaker of the National Assembly informed the Speaker of the Senate of the approval of the special motion by the National Assembly, and further forwarded to the Speaker of the Senate documents in evidence of the proceedings of the National Assembly. And whereas via Kenya Gazette number 131/78, volume CXX V1, number 163, dated the 9th of October 2024, and Article 145(3)(a) of the Constitution, the Speaker of the Senate appointed Wednesday, the 16th of October 2024, and Thursday, 17th of October 2024, as sittings convened for the purpose of hearing the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, in plenary. Further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate had the National Assembly on the grounds for the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya. And further, whereas pursuant to Article 145, as read with Article 151(b) and 2 of the Constitution, and Standing Orders 78 and 79 of the Senate Standing Orders, the Senate also had counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, during cross-examination of the witnesses of the National Assembly on the grounds of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Noting that His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, did not appear during the afternoon sitting of the Senate on Thursday, the 17th of October 2024, further noting that the counsel for His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, sought an adjournment of the Senate until Tuesday, the 22nd of October 2024 at 9 a.m. to allow His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya, to appear and give evidence, if any, on the grounds for his proposed removal from office by impeachment. Further, noting that pursuant to Article 145(4) of the Constitution, a proposed impeachment hearing for the removal from office of the Deputy President must be concluded within 10 days from the date of the hearing of reading of the charges, which period in this case expires on Saturday, the 19th of October 2024. Now, therefore, the Senate resolves, 1, to adjourn the afternoon sitting of Thursday, 17th of October 2024, and pursuant to Standing Order 34(4)(c) of the Senate Standing Orders, to hold sittings on Saturday, the 19th of October 2024, commencing at 9 a.m. until 1 p.m. and 2:30 p.m. until conclusion of business in the order paper of the day, in order to conclude the hearing and determination of the proposed removal from office by impeachment of the Deputy President of the Republic of Kenya. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? Nay. The nays have it. Now, honorable senators, the motion having been defeated, we will proceed with the hearing program as had been circulated this afternoon, in which case then we will move to closing statements by the parties. Yes, Senior Counsel Paul Mwite.
Mheshimiwa Speaker, through you, let me recognize the right of this Honorable Senate to decide any issue, any question put to it democratically, which, Mr. Speaker, is what has happened. Arising from that decision of this Honorable Senate, Mr. Speaker, we as the legal team representing the Deputy President are not able to continue appearing without instructions. So we humbly and with a lot of respect take your leave, Mr. Speaker, and the leave of this Honorable House. Thank you.
Now, Honorable Senators, we shall move to hear the closing statements by Counsel for the National Assembly. Clerk, you may now proceed to read the order.
Order number 3, hearing and determination on the proposed removal from office by impeachment of His Excellency Rigathi Gachagua, EGH, Deputy President of the Republic of Kenya.
Counsel for the National Assembly, the floor is yours. You have up to 60 minutes.
Thank you very much, Mr. Speaker, sir.
Statement.
On behalf of the National Assembly, we have a total of 4 advocates who would be sharing the time that is allocated to us. Leading the pack, Mr. Speaker, sir, is Senior Counsel Otiende Amolo, to whom I will cede the floor.
Honorable Speaker, Honorable Senators, I thank you. And this being my maiden appearance on this matter, I sincerely hope I did not drive my learned friend and his team away. But Honorable Speaker, Kenya is indeed a mature democracy. We are so mature that, Mr. Speaker, we gave ourselves the most modern constitution in recent history 14 years ago. We are so mature that 7 years ago, we had the nullification of the only presidential election.
Honorable Senators. Senator Fernandi, take your seat. Senator Kipsang, may the Counsel for the National Assembly be heard in silence.
Thank you, Mr. Speaker. 7 years ago, we had the nullification of the only presidential election known to history. And today, Mr. Speaker, we are conducting impeachment proceedings unknown to this continent outside of the removal proceedings in a parliamentary system in South Africa. Mr. Speaker, I want to thank you and the Senate for demonstrating the maturity of a democracy. So much so that even when the Deputy President is unable to appear without anything on record, this Honorable Senate has accorded the Deputy Speaker the opportunity, the Deputy President, the opportunity for his counsel to be present, and they have voluntarily exited. The right to appear in person or by counsel is a right under Article 145. But like every other right, you can choose to exercise it or not to exercise it. The idea and the fact of these impeachment proceedings being open as they are and being so democratic, even to vote on the procedural motion, shows how mature our country has become. Mr. Speaker, before the 2010 Constitution, we would not have been here for this process for 2 days. We would not have been taking this process in the National Assembly. The President would sack the Vice President at whims, including for not liking the color of his shoes. The fact that we are here in a situation where to impeach a Deputy President, we have to go through these processes, Mr. Speaker, it shows our maturity. But let it not be mistaken, Mr. Speaker, as some people have, that the process of impeachment is a criminal trial. When you hear people ask the mover of the motion, do you have any proof? Can you demonstrate? It means they are confusing this process with a criminal process. It is not a criminal process. Mr. Speaker, what we have in impeachment is a halfway house between the whim before 2010 and the beyond reasonable doubt proof in a criminal trial. In the words of Article 50, all you have to show is reason to believe. Reason to believe. What the lawyers would call just a prima facie case. You do not have to demonstrate beyond reasonable doubt. So all the questions that I had my learned friends putting to the mover to prove, to demonstrate, they look good to the public gallery, but they add no value to the test for impeachment. Mr. Speaker, impeachment is like a vote of confidence or a vote of no confidence. Just the same way when you vote the president and the deputy, no one asks you to justify why, because you exercise your discretion. When you lose that confidence, no one should ask you to demonstrate why. That is why it's a political process. Otherwise, it could have been a judicial process or a religious process. Mr. Speaker, it is important to make two distinctions. First, that in this process, you do not have to prove anything beyond reasonable doubt. That's number one. The beyond reasonable doubt can come later when the other processes come in, like the investigative agencies. Number two, Mr. Speaker, in courts, our courts use an adversarial system where you bring all the documents and you are restricted to what you have brought. The process in this house is inquisitorial under Article 145 all the way to 149. And therefore, it allows this house to go beyond what the mover has brought or beyond what the other witnesses have brought. And this house has exercised that jurisdiction quite maturely. Mr. Speaker, I want to suggest that the idea of impeachment is one which is legal in process only, legal in process, but political in content and merit. As long as all the legal processes for fair hearing are observed, it is not open to anyone to question the merit in terms of the decision of the National Assembly or the Senate, because the safeguard is in the numbers. That is why before you move it in the National Assembly, you need 117 members. For it to pass, you need at least 2/3. Even in this House, in the legal technicalities. Mr. Speaker,
a person must be heard, and there is no possibility or there is no rule that says that you can be condemned unheard. So when the Senate decided to take that approach, we decided to take leave, because we'll be sitting in an act, or rather we shall be perpetuating an illegality if we were to sit in Parliament without adequate instructions from our client. So we also take this opportunity once again to wish the Deputy President quick recovery.
What next, Wakili, now with this decision? What next?
The course of action will be decided as and when time is ripe.
What is the condition of the Deputy President as of now? And you also failed to provide medical reports. Why is so?
The matters of the health of the Deputy President. The matters of the health of the Deputy President are matters of the state. The only person who can inform the state on the status of the health of the Deputy President is the head of state. We lawyers, our instructions are limited to representing him in the Senate.
Under 151A, under 151 is removal. To that extent, the question of removal in 151, you can use the same standards in Article 181. But B, it says, or on impeachment. There is no other provision for impeachment, and we have not undertaken impeachment in this country. For that reason, Mr. Speaker, while the wording might look similar, the principles are different. Because for removal, for example, under 151, it's a strict legal process. You have to show and demonstrate that the Deputy President has physical or mental incapacity. But when it comes to impeachment, it's a different matter. It's more of a political matter. Mr. Speaker, Impeachment is a demonstration of impropriety, of unfitness for office, of it's taking political responsibility. Indeed, Mr. Speaker, in a representative democracy, it is the way of unvoting someone you had voted. Otherwise, you would be having a fresh election to decide, should we now remove this person from office? It is too expensive. The fact, Mr. Speaker, that you have 82% in the National Assembly voting for impeachment and 2/3 if it succeeds in this House, you translate it to the millions that it represents. In the National Assembly, 82% translate to about 42 million out of the 50 million Kenyans. That is a significant number. Mr. Speaker, if this House is equally to vote, you translate it to the equivalent number of people it's representing. It is not a heavy matter. If it was any less, it would have been a decision for a single judge. Mr. Speaker, allow me to address two things, then I sit, in terms of substance. One, you have 11 charges. 4 of those charges oscillate around one issue, and that is the utterances by the Deputy President. And the charge is he made insightful and discriminatory utterances.
And I think it's only fair that the rights, privacy of His Excellency the Deputy President be respected. The question that has been decided at the Senate, I think there are provisions in law, the Constitution, the standing orders, which we don't want to interpret because they are subject to many interpretations. Our colleagues on the other side, they will interpret what suits them. Of course, we'll interpret what suits our client, but I think we made it clear. Our lead counsel, senior counsel Paul Mwite, did cite Article 145, 6B. He also cited Standing Order 11. And when you read those two provisions together, you find there's room. So it is a question of the Senate, the Speaker of the National Assembly, the senators, to deliberate and come up with what they think suits not only them or selfishly, but also the country and the family. So I think it's unfortunate that the majority voted against the motion which was put before them. I hope that at the end of the day we'll consider the importance of this country.
What would you describe as happening now?
Well, of course you heard what the Speaker said. They are proceeding, right? And I hope that we'll consider generally the great nation of Kenya, the people of Kenya, and let's see how things unfold.
Wakili Swanya, at the National Assembly, you had an issue with the presiding, citing the Speaker being biased. How would you rate the presiding of the session at the Senate?
And just to add on that, do you think that Gachagua has been afforded a fair hearing as it is required in the law in the Senate?
Well, I think you saw that our client cooperated all through. It's only unfortunate that it got here at the tail end of it. But we've been there. We prosecuted our case properly, right? And the issue of bias, that always will be tested after the conclusion of the matter. So it's not a matter for us to discuss right now, but I think it's unfortunate, the decision that the Senate has taken, and we wait to see. Thank you.
Those who are saying the Deputy President is taking advantage, is an opportunist. What do you have to say about that?
Come again? What you said?
They are saying
one of the senators asked, for the justification, and I had the lawyers refer to the Schedule 3 of the Political Parties Act. Mr. Speaker, I invite the senators to look at Schedule 3, Clause 3E. It is very specific. It talks of sharing positions in the coalition structure not sharing positions in government. And to try and mislead this August House makes it an aggravation of a wrong. And I invite you, Mr. Speaker, find that there was a breach of this, and I think the worst of all is we were able to play a clip of the Deputy President after showing what he had uttered, saying that he has no apology. He said he has no apology.
But when we got in there, we were told he has been rushed to the hospital. Now the question is, what is the rush with the Senate? We had tomorrow, Friday, we had even up to Saturday. Where do we want to conclude this issue today at night with the absence of the Deputy President, accused, who is supposed to present his case? And Kenyans have understood, have seen these as allegations. We have questioned, asked him question. We asked him, tell us this. He says, I think, I don't know, I'm assuming, I imagined. So it is a sad day for this country, because we believe that as a Senate, which is the upper house, we should be very patient, wait for the Deputy President, because things happen. You know, people are trying to portray it might be a trick, but remember how many times you're with your friend and you give the stories the next day in the morning. I was with him, he was laughing, and then he's no more. But we are saying the doctors are taking care of him, and he was willing. Even if he was to come here in his hospital bed, he is willing to testify. So it is very sad to see that the Senate is in a rush to determine the case without listening to the Deputy President. So what we are saying is that Kenya has, we have seen how the process has been. We have seen how the Deputy President has been treated. Of course, being treated with allegations that are not able to be substantiated. Kenyans have seen. So it's up now to the Senate to listen to the councils who have now been given 60 minutes to give their closing remarks. And those who have been given the closing remarks are members of parliament. They have taken over the Senate. The person who is speaking as we speak, or as I left the house, is Otiende Omolo, a member of parliament. There is another honorable member there, I don't remember his name. They have taken over the Senate. So what we are saying is that we had gone well as an upper house. And I would implore to my colleagues, the senators, please, we should not crucify somebody who is in hospital, in his hospital bed. At least let the man stand up and allow him to come to the Senate so that we can listen to him. Otherwise, it is a sad day for this country. I don't know what they rush for, and I believe for them, the councils of the Deputy President will do what is necessary. And also as a senator, I will do what is necessary.
Senator, it seems like you've thrown your hands in the air and given up. You've left the stage instead of fighting on. What is the end game in this?
I'm adverse inference that either there is no such document, or if there is, it does not deal with that finding. Mr. Speaker, I want to submit that there is good reason why that document was not produced. Why would you produce all the agreements of Kenya Kwanza and produce all sorts of other things except one page of a document that is the most important document? As it is, you do not have any document that shows that this finding was negated. Mr. Speaker, I want to suggest that had it been produced, we would then have demonstrated that that document is unlawful. Because in law, and I submit respectfully, once you have been found guilty of what amounts to a criminal offense, you cannot then subsequently compromise it, because this is not a civil claim. A crime is a crime against the state. It is not personal to the Asset Recovery Agency. And therefore, those findings can only be set aside by positive findings of a superior court, and there's none. So the record shows that Rigathi Gachagua was convicted of corruption. And what that means, Mr. Speaker, that not only was he convicted, but even to come here and allege that he was convicted and thereafter, you know, they entered some sort of negotiation, is in itself evidence of abuse of power. because he was convicted 10 days before election. Shortly thereafter, it is alleged they compromised it in what would be an illegality. Mr. Speaker, on that account, ground 7 of the charge must succeed. Respectfully, Mr. Speaker, honorable senators, I plead with you to find the Deputy President guilty of the grounds as charged. Thank you very much. Allow me now to introduce the Honorable George Murugara to take over.
Thank you very much, Mr. Speaker and honorable senators. My name is George Gitonga Murugara, Member of Parliament, National Assembly, and the Chairperson of Justice and Legal Affairs, and I'm here to represent the National Assembly with my colleagues. Honorable Speaker and senators, I'll deal with only one point which supports ground number 11 on the impeachment. And the ground 11 is insubordination and failure to actually act collectively with the other members of the cabinet and the presidency. There was an argument that was raised that some of the alleged misconduct on the part of the deputy president were actually committed when he was not the deputy president and therefore do not apply to the proceedings before this House. Reference is made to Article 151B of the Constitution, which provides that the ground for impeachment would only be serious consideration of serious reasons to believe that an offense has been committed. There is no time limit that is set, because once there are reasons to believe that an offense has been committed, then that stretches back to whatever time that offense would have been committed. This is to say, if in the pendency of the life of the presidency or the deputy president, it is discovered that before you assume the office, you committed an offense, that forms a ground for impeachment. This leads me to the next argument, which are the admissions that the deputy president actually made before the House. Clearly, he admitted that the issue of shareholding in Kenya was live and he was part and parcel of it. Therefore, Kenyans were shareholders. He actually admitted in the House and also in the press in the country that he believed the president was behind this motion. He also admitted that he had actually gone against the principle of collective responsibility on the basis that the cabinet had made unconstitutional decisions, which decisions he had to disobey. He also went on to dismiss this parliament as a theater of the absurd, and that he did not expect much from here. The question is this, and that, honorable senators, you have to grapple with. If the deputy president was actually to be saved by this House, with whom would he work? He would not work with the Kenyans whom he has antagonized with his shareholding notion that he has spread across the country. Number two, he would have difficulty serving with his boss, whom he has accused of being behind this motion. He would not actually work with the cabinet, where he is responsible for everything that is done in the cabinet and the sub-cabinet committees brought together by the principle of collective responsibility. He would not be able to work with this parliament, which he has called a theater of the absurd. With whom would he work? This is the question you have to ask yourselves. What we have before us today is like a marriage, and I have to draw that analogy because actually the position occupied by the subject of the discussion and the motion, the Honorable Rigathi Gachagua, is now untenable. He cannot hold that position because his position is irretrievable. He cannot work with any of the organs and bodies he's supposed to work with. Therefore, the position being irretrievable, then it means actually he has to be impeached. And I implore upon you to actually do so. Where a marriage is irretrievably broken, you cannot apply any law. The marriage is gone. Whichever law you try to apply, it does not matter. For the Deputy President today, we cannot apply any measure of legalese because this is not likely to assist us in any way. The position remains, this is a political process, these political offices they are holding, and therefore they are irretrievably broken. As I pen off, Honorable Senators, Honorable Speaker, sir, I'll refer you to a biblical book in the Old Testament, the book of Jonah, chapter 1. And when the senators retire, they can actually look at that, the entire chapter. What happened here when Jonah disobeyed the command from his superior, and that was the deity? He actually had to flee. And when he fled, he took a ship to a different city, not where he had been commanded to go. What remained was, on the journey, the waters were faced with tempest, and eventually the tempest had to be calmed by tossing Jonah out of the ship. The ship here is actually the presidency. The ocean is actually Kenya. Jonah is the insubordinate deputy president who actually cannot work with the entire government and the country, and whose position today, as he holds, is untenable. With those remarks, I urge you, honorable senators, to actually uphold this motion, and to the best of my belief and conviction, not only ground 11, which I have submitted, the rest of the grounds have been approved. Thank you very much. 2 minutes to Honorable Zamzam, who is also going to make a statement and a submission. Thank you very much.
Mheshimiwa Spika, kama mwakilishi wa bunge wa eneo bunge la Mombasa na bunge la taifa la Kenya, Mheshimiwa Spika, leo nimekuja hapa kuwaletea yale mashtaka ambayo yameonekana katika bunge letu, Mheshimiwa Spika. Mheshimiwa Spika, mengi yamezungumzwa. Mimi si mwanasheria, lakini mimi nazungumza kama yule Mkenya ambaye yuko pale chini, hajui sheria, hajui nini, anaomba amani katika taifa, Mheshimiwa Spika. Mheshimiwa Spika, video zimechezwa katika bunge hili. Tumeona Mheshimiwa Naibu wa Rais akijipiga kifua, hasa kule Taita Taveta. Nimeona Mheshimiwa Spika akiwaambia kuwa hawana shares, na akawaambia nyinyi kama mnataka hisa mungoje 2027, manake hata rais akinambia mimi niweze kuwaletea maendeleo, na mwambia kwanza subiri niangalie kwenye mfuko wangu wakiwa kama wako kwenye orodha ya kupewa maendeleo. Mheshimiwa Spika, Mheshimiwa Spika, ifahamike kuna wakati mmoja Kenya iliingia kwenye vita sana, Mheshimiwa Spika. Tuliona maiti ya kina mama, mtoto hajui mama amekufa. Mtoto alikuwa ananyonya matiti, Mheshimiwa Spika. Mheshimiwa Spika, hatuwezi kutaka taifa hili lirudi kule tena, Mheshimiwa Spika. Mheshimiwa Spika, ndani ya Mombasa nina wajane ambao wananitegemea sana, Mheshimiwa Spika. Uniletea malilio yao, na leo mimi kama mama kaunti wa Mombasa nalia kwa sababu ya mayatima ambao waliachwa na ndugu ya naibu wa rais, Mheshimiwa Spika. Haiwezekani kuwa leo mimi na mume wangu tutafute mali yetu na tuna watoto wetu, kisha akifa aende mbele ya Mwenyezi Mungu nije nipokonywe mali yangu niache na watoto wangu wakihangaika, Mheshimiwa Spika. Ukiangalia umri ya hawa watoto wa ndugu yake Mheshimiwa naibu wa rais, wametoshea kupewa urithi wao, Mheshimiwa Spika, lakini hata kuna tetesi mwingine yoozea kule kwa jela, Mheshimiwa Spika. Kwa hiyo Mheshimiwa Spika, mimi nasema, nilisikia mwanasheria akisema to save makanga, mimi nasema makanga ameiba pesa ya abiria dereva hana pesa ya kupelekea mwenye gari. Kwa hiyo mimi nasema wamwache dereva apeleke abiria mpaka stesheni ya mwisho, kisha akifika kule atajua atatafuta makanga mwingine namna gani. Mheshimiwa Spika, hatuna sisi uchungu na watu wa mlima, lakini tunachosema tulikuwa na Uhuru, tulikuwa na Kibaki, tulikuwa na Kenyatta, hatukuwahi kuona mambo ambayo tumeona kwa Deputy President. Mheshimiwa Spika, huyu ni sumu, atavuruga Kenya, ataharibu Kenya. Naomba bunge hili la Seneti, amani ya Kenya iko kwenye mikono yenu. Na waomba mtoe uamuzi wa uhakika. Huyu jamaa hapendezi kabisa kuwa katika nafasi ambayo yuko ndani sasa. Na waomba kwa heshima na taadhima tuweze kumtimua leo, Kenya iweze kupata mtu ambaye atamsaidia rais kufanya kazi akiwa ameweka amani na umoja wa Kenya mbele. Asante sana Mheshimiwa Spika.
Mr. Speaker, sir, very briefly, I will wrap up the submissions on the part of the National Assembly. I'll endeavor not to repeat what has already been captured on the record. Mr. Speaker, sir, I've agonized and reflected on the place of impeachment proceedings, not just in our country, but across the world and across other democracies. Mr. Speaker, sir, I've had occasion to look at the history, particularly of the United States of America, from the days of Andrew Johnson in 1868, Richard Nixon in 1974, Bill Clinton 1998, and Donald Trump 2019. Mr. Speaker, sir, I asked myself, what does impeachment proceedings seek to serve in a democracy? In my reflections, one of the clear conclusions is that it is a check and a balance through which the populace can then hold their leaders accountable. It is an avenue through which the populace can ask their leaders whether they're doing that which is in keeping with the social contract or the understanding that they had at the point of election or delegating their direct powers to those elected leaders. So in the context of Kenya, where then do we find impeachment? Mr. Speaker, sir, our history has taught us very bitter lessons. We remember the events that bedeviled our country after the 2007 elections. It is after those events that we gave ourselves a new constitution. In that new constitution, Mr. Speaker, sir, we found it necessary to, in an unprecedented way, speak about our values, speak about the fabric of our society, the things that pull us together, the things that we share as a people. The preamble to our constitution, in particular paragraph 3, reads, "We, the people of Kenya, proud of our ethnic, cultural, religious diversity, and determined to live in peace and unity as one indivisible sovereign nation," and continues so on and so forth. From those words, we realize what the thinking of the Kenyan people was right from page 1 of framing of our constitution. We then went to substantive provisions. A lot has been said about Article 10 of our constitution, to the extent that it speaks to the values that as a people we want to be associated with. We have dedicated a whole chapter of our constitution to the questions around leadership and integrity. It then tells us how central the values that we hold are to each other as a nation. Now, if we look at impeachment from that lens, then we realize and appreciate that impeachment then comes in to hold our leaders at an even higher pedestal, so that we have a tone at the top that is acceptable, a tone that gives us what has been called elsewhere political hygiene. We have had occasion in this country where people who have been in positions of leadership have been treated in what other people have thought has been harsh treatments. But it is because when there's a tone at the leadership to be set, it must be clear, it must be vibrant, and it must be the right tone. We've had leadership, people from the leadership who've lost their office because of having pinched somebody. We have people who have lost their offices because of utterances that were considered inappropriate. A slap has gotten somebody to go through a fairly painful process. It is because the slap is not necessarily the issue, it is the message that it sends. And so similarly, when we talk about our leaders, we then must ask ourselves, what does one wrong word do to the fabric of our society? It is on the basis of that background that we then consider the impeachment motion that is currently before this House. My colleagues who have spoken before me have taken us through the provisions of Article 150, 1B, which then speaks to the very grounds that this House should consider in whether to impeach His Excellency, the Deputy President, or not. I wouldn't want to go into those grounds because the record before this House contains material in support of those grounds. I would urge, Mr. Speaker, sir, that now that His Excellency, the Deputy President, has had occasion to present material before this House, that this House could consider in response to the motion for impeachment. When you retire to debate, to deliberate, we urge that you take into consideration the entirety of that material. We also ask that you also take time to look at what the mover of the motion presented before this House, as well as all the witnesses, including what came from public participation. That would give us an opportunity to, in a very objective way, reflect on what and how to deal with the questions that have been presented. I need not go into the specifics of each of the charges, but if I was to give examples, when we have a leader occupying the high office of the Deputy President of this country, somebody who is required by the Constitution to take an oath confirming or affirming to Kenyans that they will not divulge whatever comes out of secrecy, out of confidential conversations that come to their knowledge by virtue of the office that they occupy. If that person then defies that bond or that commitment that they've had with Kenyans, it is a gross violation. Similarly, when we have somebody occupying the space of the high calling of the office of the Deputy President, admitting issues that would amount to conflict of interest between his personal interest, his family interest, and which have financial implications. Again, our laws then dictate that those are reasons that would be sufficient to impeach such a Deputy President. We've had examples that have been given about utterances that have been considered to be unpalatable. Again, looking at the entire framework of what our Constitution anticipates, looking at what those words would mean to a man off the streets of Nairobi, off the streets of Mombasa, or any other place. If we all come to the understanding that those words taken in their natural meaning could cause some measure of discomfort, they are considered to be divisive, they are considered to be of such a nature as to bring or sow seeds of discord between us as people in this country, then it is the responsibility of this House to speak, and to speak on behalf of the people of Kenya, because it is one way of ensuring that there are checks and balances that flow from the constitutional powers vested in this House. Mr. Speaker, sir, as has been demonstrated through the many tons of documents that have been availed before this House, the cross-examination that has attended to the witnesses that have been before this House, and the material that has been placed by the mover, by all the parties who've had an opportunity to participate in the proceedings of this House, we have absolutely no doubt that this House is perfectly capable of making the appropriate decision in each and every of those counts. And just for emphasis, Article 150, Sabbatical 1B gives us 3 grounds. We do not have to have beyond 1. Any one of those is more than sufficient to make the call or to pull the trigger on an impeachment motion. Mr. Speaker, with that, I rest, and we thank you for according us this opportunity this evening. Most obliged.
So, are you done now with your submissions?
Yes, Mr. Speaker, sir. We are done.
Thank you. Now, honorable senators, I'll refer you to the program. You will notice that after the closing statements from the parties, the Senate is supposed to move to a closed session to deliberate on the issues that have been raised. And that is pursuant to our rules of procedure. That is demanded of us by the rules of procedure. So at this juncture, I will allow the parties to retire as the Senate moves to a closed session. That closed session will take us not more than half an hour. After that, we'll come back. Once we are back, there's going to be a special motion contained in an order paper. That is the motion that will allow debate culminating into honorable senators getting the opportunity to cast their vote on each of those charges, of the 11 charges. So, Counsel for the National Assembly, you may now retire. Once we resume open session, of course, you'll resume your seats.
Thank you very much, Mr. Speaker, sir.
The media and live broadcast has to cease forthwith.
Wakenya kote nchini wanaendelea kujishindia mamilioni kila wiki.
Nimepata hiyo pesa sasa.
Bonyeza *487*3#, weka 50 bob tu upate content na point 50 za kuingia kwenye draw ya 50,000 kila siku, milioni 1 kila wiki na grand prize ya milioni 3.
Ile kubwa sasa. Hata mimi natamani milioni 3.
Jibambe na content nyingi zaidi, uongeze chances zako za kushinda. Jipange na view sasa.
Hii mchezo ni ya ukweli. Huwezi chukua chuma mbaya unataka kutengeneza nayo kitu mzuri ingiane. Chuma ya Doshi haina twist. Chuma ya Doshi iko straight kabisa.
Doshi Steel, chuma ya nguvu.
Great yummy taste, gotta hack it. I spread bread, pate nguvu, gotta pack it. Napaka nywele design ya Mogoro. Blue Panda, Juni natural cocoa. 5 vitamins, una grow plus ni tamu na ni tuna hack snack na ki-blue banchoko.
Kwa chuo cha Kilimanjaro Institute of Technology and Management kilichopo Mwenge jijini Dar es Salaam na chenye thibati na usajili wa NACVET number REG/ANE/029 anapenda kutangazia nafasi za masomo kwa ngazi ya diploma na certificate katika kozi za IT, Business Administration, Accountancy, Procurement and Supply, Front Office na Hotel Management.